Good morning, good afternoon, and good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents affect our daily lives. Listen, I wanted to come on here really quickly, and I wanted to go over a couple of things in regards to the Jonathan Majors uh, trial, incident, whatever is going on. Um, it's late at night, so I may not have all the words that I need to have to talk about this. But before I do that, I want to do a little housekeeping. Please like and comment this and subscribe to this channel. I'd appreciate it. I'm on a quest to get to 1,000 subscribers. Here it is scrolling from the bottom. I really do appreciate that. If you do, tell a friend, tell a kin, tell that heifer you can't stand that I'm over here making these videos, y'all. I am doing that. And also, I am doing more pop culture chats, and this is what this falls under. Because there is a writer's strike and there is an actor strike. There is some things that are going on. But for now, I am going to be doing my series of retrofit is what I'm calling it, where I'll be reviewing movies and movies pretty much of old, probably that have come out last year and going back, just so that we can fill up some space here. And also, I've always wanted to review those videos, but I never did have the confidence to do so. But what I wanted to do today, really, really quick. First of all, I want to thank Chillmonger for showcasing me on his live today. I really do appreciate that. I wanted to clarify some things on there in regards to New York City and New York State, rather, about how these trials are supposed to go and how quickly they're supposed to go. New York State is under a bail reform, and they're also under a speedy trial reform. And those two incidents come from or have been pushed from the Khalif Browder case. If you're not familiar with that, you can actually Google it. But I'm going to give you a very brief surmise of what I understand it to be. Basically, there was a young man named Khalif Browder. He was arrested for stealing a book bag which contained a laptop, and I think it was worth $1,000. What happened was is that he had a bail set for, I want to say, $5,000. But because of his financial and socioeconomic status, he couldn't meet that bail. So he was in jail. And what happened was he languished in jail for about 3 years because he couldn't make bail, and they were not setting trials or anything for him. We became aware of him because of the fact that while he was in jail, it was recorded that either other inmates and or the correction officers were physically assaulting him. And also, it was made aware that this young man was put in solitary confinement pretty much most of his stay there. So, number one, he was accused of stealing a book bag with a laptop in it, and most laptops are valued at anywhere $3,000 and under. He also couldn't make his $5,000 bail, which meant that he had to put 10% down, which would have been $500. He did not make that. So therefore, I don't know. I will say that I do not know if there was a hearing after the bail hearing, like the arraignment to talk about the charges and all of these different things. I don't know if a hearing happened, but whatever happened, that he languished in jail. And the only way somebody found out about him is the fact that it was recorded that the corrections officers were beating him. Once they realized who he was, and they realized that this young man has been in jail for 3 years and he has not had a court date, There was a big up in arms. He was then subsequently released. After he was released, because of the fact that he languished in jail and he had experienced all those different things, even though I think his family were suing the state, uh, sadly, while he was out, he committed suicide. So from all of that, and in other cases, New York did a bail reform because no one should be languishing in jail for 3 years because they can't make a $500 bail. So they did some bail reform, and they also did some speedy trial reform. So in other words, that the prosecution has a time clock as to when they're supposed to do certain things. And why am I bringing this up? So let me share my screen. All right, here we go. I'm sharing my screen here. And this is an article from Deadline. This was going over the last trial because he was supposed to have started his trial, Jonathan Majors, on August 3rd. And on August 3rd, the people, which is the prosecution, came in and said, and I'm going to just highlight this little section right here. They told the judge that, and this was Assistant DA Kelly Galloway, told the judge the people are not ready. The people are not ready for trial today, and noting that they needed more time for discovery. Taking that in and undoubtedly aware of the attention of the matter that has attracted, Judge Gaffey told the prosecution that the clock is ticking. Time will continue to run against the people. And I thought that that was a great point to point out. And that gets to where I was talking about earlier about the bail reform and about the speedy trial reform. So it's not really affecting Jonathan Majors in regards to the bail because he's in the socioeconomic status that he would have been able to pay the bail in which he did, or I think the bail was set. He was let out on his own recognizance, but a partial initially a partial um, restraining order was levied against him. And then when he went back to court, now that was in March, when he went back to court in May, a full restraining order was levied against him for him to stay away from the victim, Miss Grace Jabari. So we're talking about this time clock that the judge said that the prosecutor that the clock is ticking. And what did he mean by that? So let's go into this article. Let me see. Now this is from Tillum and Associates. I believe they are attorneys that work in the New York area. There is, and I couldn't pull it up because I couldn't remember the website that I went to, and that's my bad. But it says here, the right to a speedy trial applies to all New York criminal charges, including but not limited to traffic tickets, misdemeanors, according to the CPL 30 30. The prosecution must be ready to try a felony within 6 months. Okay. For misdemeanors with maximum penalties. I don't know why that word is so flicking on my tongue. Greater than 3 months. The prosecution must be ready to try these cases within 90 days. Misdemeanors where the maximum penalty is less than 3 months, the prosecution must be ready to try these cases in 60 days. For violation, the prosecution must be ready to try these cases within 30 days. Now, why is that important? So in the Jonathan Majors case, the clock is ticking because the initial court hearing was in May. That is when the defense presented evidence to the prosecution, probably 2 weeks prior, about why they believe that the case should be dismissed. The prosecution then turned around and said, okay, we're dropping the charge that has to do with the strangulation, and we will review this and we will meet back. I think it was in June 29th or whenever it was in June that they met. When they met at that case, at that time, the defense then presented pretty much the same evidence. I think it was June 20th. They presented the same evidence and then asked for the case to be dismissed. The prosecution denied that, and therefore, that's when the defense said, okay, we want to go to trial. Once that was said, a trial date was set for August 3rd. Okay. So now they've got 90 days. I think that's what it says, 90 days. So you're talking about from the time that they decided that they were going to go to trial to that was June the 20th. And then they set a trial date for August the 3rd. So I think if I'm not mistaken, and if I'm reading this right, and if you all are in New York and you all are lawyers and you understand what's going on, and if I said something out of order, please correct me and down in the comments. I would appreciate it. So basically, what's happening is that when the prosecution came to court today on August the 3rd, and they informed the judge that they were not ready for court, he was reminding them that the clock was ticking. So that tells me that they have until October to effectively try this case, or this case has to be dismissed. So we're going to see whether or not the prosecution will comply with what's going on, because whether they start, if they do not start in September, I am if they do not start in September, from my understanding of what this law is, that the judge will have an opportunity to dismiss this case, because if the prosecution ain't ready, there is no case. Now, I do understand that they presented the defense with a 2 terabyte hard drive of evidence of discovery, but you must remember they also told the judge, let's get back to that article. They said that the people are not ready for trial today, and noting the need for more discovery. So they claim that they are discovering more information in regards to this case. So the judge, like I said, the judge reminded them that the clock is ticking for them. So if they're not ready, if they're not ready by September, they're not going to get ready. And even if he does delay this case to October, once October hits, and if they're not ready, according to, if I'm reading correctly, let me go back to the article, that they can dismiss this case. So I wanted to kind of clarify that. That is something that is happening in New York that they have to kind of go over and talk about. So we will see. We also understand and know, and I know that there is a Twitter post about Grace Jabari, and that she fled the jurisdiction because last month Jonathan Majors filed charges against her. We know that she left New York because she is from England. And so therefore she was not here on a permanent visa or anything like that. So she went back to her home country. So she did not flee the jurisdiction. She left. So what's going to be interesting to see is if she is going to return back to New York for this trial. Again, I want to thank Chillmonger for referencing me in his live about this situation. So I wanted to kind of clarify what I had said in a comment post that he made. I had referenced the Megan Thee Stallion trial and Tory Lanez, and here's what I was talking about. Let me see if I could find real quickly. Hold on, y'all. I'm going to hold on. I'm going to try to pull that video up. Let's see. I think it's this one. I don't want to play it. I want to go down to the comments. All right. Let's see. Let's see. Ooh, you can't see that. I hope that's good. So he asked a question. Hold on. He asked, do you think the DA gave her the heads up to leave the country so she wouldn't get arrested? And I'm going to read to you really quickly what my comment was. I stated that that's a good question. Ms. Jabari retained a lawyer who has been in contact with the prosecution. Now, according to a source, Ms. Jabari left the country at the end of May. Maybe that is why the prosecution deactivated the iCard so they could ensure that Ms. Jabari returned without the fear of being arrested. The prosecution case hinges on the testimony of Ms. Jabari, so they need her to make this case. So there's the threat of Ms. So the threat of Ms. Jabari's arrest would definitely have an impact on her testimony and her willingness to return to the country. And I put in parentheses, we saw something similar with the case of Tory Lanez and the testimony of Megan's best friend. And also, I mentioned, I'll read the whole thing. The prosecution is on a time clock because in New York, they have to prosecute misdemeanors within 60 days from the initial set court hearing, which was August 3rd. They have to dispose of this case by October or it'll be thrown out. Okay. And that's all right here, if you see that. I mentioned the Tory Lanez case because if you would go back to, I have a video, probably 3 videos before this one, 4 videos before this one, talking about the Tory Lanez case. And what we found out in the Tory Lanez case, if you remember in December when the trial was going on, a lot of the Megan Cuniff, who was the court reporter in the case, she indicated that Kelsey, who was Megan's best friend, was very reluctant and acting funny about answering the questions, even though she had immunity. And no one could understand why she did that. Well, in February, what is this? This is July. So this happened to be back when I did that video. Tory Lanez had fired his old attorneys, and he signed a waiver to have his attorney-client privilege with those attorneys uh, released, so that he can go over the information that those attorneys talked to him about. And in that information, we find out that his attorney, Miss Holly, who was also present on the O.J. Simpson case back years and years ago, she recused herself from the case. Partly why she recused herself from the case, number one, the prosecution was threatening to charge her with corruption of a witness, which was Kelsey. So what did happen? And as I talked about in that video, Kelsey's had an attorney negotiating with Tory Lanez and his attorney about paying her medical bills. So when the prosecution found out, because she had, let me back up. Kelsey had done an interview with the prosecution in September, which was 2 or 3 months before the trial started. And she gave the prosecution all the information that she had, and she was willing to give that information. Well, somewhere after that, maybe October or November, the prosecution threatened the defense, Tory Lanez's defense, Miss Holly, of reporting her to the licensing board and possibly charging her with and these are my layman terms, corruption of a witness, because at that time she was in contact with Kelsey's attorney about Tory Lanez paying her medical bills. And once the prosecution got hold of that, I guess she made a bid to, uh, I guess, threaten her. But what happened was is that Miss Holly recused herself. And once she recused herself, I guess that, she no longer was in contacts with Megan's attorney. And I guess she explained to Megan's attorney what was going on. And so therefore, Kelsey was feeling like the prosecution was trying to accuse her of taking a bribe or taking something like that. And because of that, when Kelsey got on the stand in December, that is why she was acting, she was very reluctant to answer the the prosecution's questions. She was very apprehensive because in Kelsey's mind, the prosecution was trying to catch her up, so to speak. And so she wasn't willing to play that game. So she wasn't willing to answer those questions as forthcoming as she was in September of the same year when she sat down and she had an interview. And so the prosecution was acting like they didn't understand. And the reason why I reference that with this Jonathan Majors case is the fact that the prosecution needs Miss Jabari's testimony about what happened to her. And if that iCard, because Jonathan Majors went in right the day after, I think it was June 21st, he went into 2 precincts and he filed charges against Miss Jabari. If that iCard would have remained active, Miss Jabari would not have any reason to come back to testify because she had the threat looming over her that she was going to be arrested. So basically, what I'm saying is that the prosecution will do whatever they need to do to get their witnesses to come in and to testify uh, for them, the prosecution. So that is what I meant by that. We kind of saw that play out in the Megan the Stallion trial. I mean, excuse me, Megan the Stallion was not on trial. Tory Lanez was. Tory Lanez was on trial. I can't think of what his name is. His real name is it Tory Peterson? Daystar Peterson. That's his name. Daystar Peterson was on trial, and that's why Kelsey was apprehensive about answering the question because she was believing that the prosecution was trying to pin her on a tampering of witness or a bribery type charge, and she wasn't with that. So therefore, she had an attitude when she went into court. So I wanted to clear that up. What do you all think about all of this? What do you think about the information that I just talked about with Jonathan Majors and the court the court of New York having a time period of when they're supposed to uh, finish with this case? I don't know if adjudicating this case was the right word, but going to trial and finishing trial and coming up with a verdict and all those different things. What do you all think about that? Leave that down in the comments for me. Again, thank you so much for rocking with me and watching my content. Again, help me reach 1,000 subscribers. Please like, comment, and subscribe. I really do want to hear your comments. I enjoy comments. I will answer comments. I'm at that stage where I can answer all the comments. I see them when they come in, and I will definitely answer them the best way that I can. Please tell a friend, tell a kin, Tell that heifer you can't stand that I'm over here making these videos, all right? And we do this every week. We do this every week. And there's always people. Bye bye.